A major update from the Supreme Court wherein lawmakers in the parliament and state legislatures are not immune from prosecution in bribery cases. The Supreme Court has said today in a landmark verdict by a 7-judge bench led by Chief Justice of India, D.Y. Chandrachud. The verdict has now set aside a 1998 judgment in which a 5-member constitution bench had upheld immunity for lawmakers in cases where MPs or MLAs took bribes for a speech or a vote in the House. Bribery, the court has said, cannot be protected by parliamentary privileges, and the interpretation of the 1998 verdict is contrary to Articles 105 and 194 of the Constitution. These two articles provide elected representatives legal immunity from prosecution to enable them to work without fear. The Chief Justice of India said that the court disagrees with the judgment in the P.V. Narasimha case. The judgment in that case had granted immunity to legislatures for taking bribes to cast votes and had wide ramifications for the years to come. The P.V. Narasimha Rao case had come up in connection with a no confidence motion against his government in July 1993. The minority government had survived with a slim margin, 265 votes in favor and 251 against. A year later, however, a scandal emerged and allegations surfaced that legislators of the Jharkhand Mukti Morcha had taken bribes to vote in support of the P.V. Narasimha Rao government. In 1998, the Supreme Court held that the lawmakers' immunity from prosecution extended to their votes and speeches inside the House. However, the Supreme Court today said a claim for immunity in such situations fails to pass the test of being necessary to discharge legislative functions. Prime Minister Modi has also lauded this decision of the Supreme Court. But what really are the larger implications? We take the conversation forward. I have with me K.V. Dhananjay. I also have with me Deshratan Nigam. We have with us Gautam Mukherjee and Joyita Basu. Let me begin with K.V. Dhananjay. K.V. Dhananjay, if you could just perhaps briefly explain to our viewers what really was upheld as far as 1998 is concerned, and what is it that the Supreme Court has really said today? What does this mean now going ahead?
Well, what the P.V. Narasimha Rao judgment had done, there were 5 judges in that case. And Mr. P.V. Narasimha Rao was one of several members of parliament who were being prosecuted by the CBI on the ground that they had in fact bribed several other members to vote or to not vote in a certain way as to save the government of P.V. Narasimha Rao. So this was a case where there were 5 judges, and of the 5 judges, 3 judges went on to say that if a member of parliament took a bribe to vote and he proceeds to vote, then he is protected under the Constitution. But however, if a member of parliament took a bribe, but he chooses to not vote in terms of the bribe pact, then he can be prosecuted. So ever after this, the day after this judgment was pronounced, there was so much of, uneasiness amongst constitutional scholars that what the court had just done was to really give a very incongruous, color to a constitutional provision. And over the next few decades, what also happened is the different benches of the Supreme Court and also of the High Courts were expressing some doubt about the correctness of this particular judgment. And that is why the judgment came up for further consideration first by 5 judges, 5-judge bench, who definitively said that the matter required reconsideration by a larger bench of 7 judges. And the 7 judges have delivered their judgment today. In it, they proceed to say this, which is, if a member of parliament or of the state legislature, so please remember this, what applies to a member of the parliament will also apply to a member of the state legislature, because we all have only one federal constitution. States in this country do not have constitutions of their own. So what the 7 judges have done today is to overrule the majority judgment in P.V. Narasimha Rao and more or less uphold the minority judgment in P.V. Narasimha Rao. The minority judgment had said that there is no immunity at all for taking bribe and then voting or not voting. So the majority judgment had said you have immunity if you vote, but if you don't vote, you don't have immunity. And today 7 judges proceed to say that if you do take a bribe, then that is an act of corruption under the Prevention of Corruption Act of 1988. Yes. And the moment you take a bribe, the offense is complete. So it matters not whether you act in terms of the bribe pact or you don't. Whether you vote or you choose to not vote, you committed a crime under the Prevention of Corruption Act, and the majority judgment in P.V. Narasimha Rao was coming in the way of prosecuting you. So that judgment is now being overruled effectively. Any member of the parliament or of the state legislature who takes a bribe to do what his public act is now commits an offense under the Prevention of Corruption Act, and he can be prosecuted. This is also the position in countries such as the United States, though this is not the case in the case of United Kingdom. So what we have done is to harmonize our laws with countries such as the United States. And the 7 judges have in fact said that India cannot afford to have a kind of immunity like this. And it's important to recognize that when a member of parliament takes a bribe to do what he does or to not do something, then he commits an offense. And it's important in the interest of probity in public life to not let that go off. So this certainly would send a chill in the minds of so many legislators in this country, in the state legislatures, and also, of course, members of parliament, irrespective of what party they belong to. Because in this country, there was, over the last 2 decades, there was this ingrained feeling amongst a sense of entitlement amongst our legislators and parliamentarians that there is no law that can touch them. Should they take a bribe and then act in terms of that bribe? And that actually effectively dissolves today. And so I think we must be very grateful to the 7-judge bench. And this is an unanimous judgment. There is no, there are no multiple judgments here. There is justice. The judgment is penned by Honorable Chief Justice Chandrachud, and the other judges have joined him in that judgment. So there is just one judgment that runs into 135 pages on the SEC SEC website.
Okay. Deshrata Nigam, in hindsight, do you feel that there was earlier then just a lack of intent to perhaps address such a gaping hole in the law itself, or the fact that there was a judgment floating around that was saving since 1998 MLAs and MPs from prosecution for a serious charge of bribery?
Well, Devika, in fact, it's very intriguing as to how and why such a common sense judgment took such a long time, and a judgment where bribery was, made a privilege rather than being prosecuted. This is something which has always intrigued me for a long time. And a person, as the paradox was clearly highlighted by Mr. Dhananjay, a person who takes a bribe, votes in favor accordingly, then he is not prosecuted. A person who takes a bribe and votes independently is prosecuted. That paradox has been solved by this particular judgment. And therefore, it was high time that such a judgment was there. Supreme Court has come down very heavily on corruption and bribe, saying that the privileges are subject to judicial review. That is one aspect which is also been highlighted in this judgment. And therefore, just prior to elections, this is a signal to the parliamentarians and the people who are contesting elections, just to be aware that there is an institution which is a watchdog of our constitution, and they are willing to go to the extent which is required. And this was an ancient monarchical law where the Britishers had the privilege earlier. And in terms of a statute, some kind of bargain was done so that they had that kind of a privilege. And that privilege has been, rightly taken away in terms because of bribe cannot be given immunity. And that is why I'm saying so that this is absolutely necessary for strengthening our democracy. In fact, taking bribe, speaking in the parliament, the way some third party wants you to speak is not free speech. It is not guided by, fearlessness or otherwise. In fact, you are motivated to do something which is criminal. And even taking a bribe or attempting to take a bribe is a crime under the Prevention of Corruption Act under Section 7. So therefore, it is the right kind of interpretation. It was high time that it was done, and it has serious consequences, and it strengthens our democracy. The first thing is probity in public life. You cannot be above law, whether you're a parliamentarian or not. And there is a parity which has been brought in this particular judgment between ordinary citizens and the parliamentarians. You are not above law. The rule of law will take supremacy. And that is where I really welcome this judgment. And this will go a long way in strengthening our parliamentary democracy.
Absolutely. Joyita, bringing you in as well, and a lot of people may not even have the exact background as to where this case even came up before the Supreme Court from, because this was not suo motu action that was taken by the Supreme Court in this matter. It was in fact in a case related to Sita Soren, JMM MLA and daughter-in-law of Shibu Soren, who was accused back in 2012 Rajya Sabha elections of taking a bribe and voting for a particular candidate, during which time she then moved the Jharkhand High Court, which refused to set aside the criminal case that was filed against her, and then this verdict of the High Court was challenged before the Supreme Court, and it was argued in fact that there is a constitutional provision which grants immunity to lawmakers that must apply to her. This was the background of the entire case. So the case was not in fact being fought, it seems, on the basis that no bribe was taken to begin with, but to the fact that there is an immunity that must be granted to me as a lawmaker. How bizarre is that something like this was even operational for so many years? And I just want to understand from you as well, because you've been a journalist for a very long time. How do you feel that in hindsight, for the past 2 decades, this law would have been misused in so many cases?
Well, obviously the law, perhaps was framed at a time when, lawmakers were thought to be above board. Nothing could be, could be wrong about them. And just for that matter, it is not just this. If you are looking at the kind of privileges that these parliamentarians have, certain things that they can get away by saying inside parliament unless and until expunged by the chair. You see, certain areas, these are very dubious. As for ordinary people like us, it seems very dubious, because when you are looking at this particular case, it's a clear case, it's an open and shut case of corruption and nothing more than that. It's black and white at one level. Whether you are taking money and buying maybe a fancy handbag, or you are taking money for your election campaign, the fact of the matter is that you are taking money. So the whole point is, you see, just as Mr. Deshratan Nigam also said, it is not just about voting. It should apply to anything that a parliamentarian is raising in parliament, whether you are making a speech at the behest of a third party, somebody outside, or if a voting is happening, it's a clear case of corruption. And if you are holding the common man to certain levels of probity, you expect certain things from him. If a person who kind of can be sent to punished for taking a bribe, why can't these people also be punished? What makes them, after all, they are people's representatives, what makes them immune from punishment? So it's actually a common sense judgment, something should have been, but I guess what has happened is, over the years, if you go through the records of parliamentarians, there must have been people who have done things which they should not have done. So there was some kind of a common consensus among, let us not touch certain things because it comes to saving our own skin. But this is the problem, this is something, this should have been done, as you are absolutely right, this should have been done long ago.
Absolutely. Gautam Mukherjee, just, your understanding of what has happened, and of course there will be now implications in the future as well, that perhaps MPs and MLAs will also be far more careful. But at the same time, the role of the Supreme Court in all of this, there's a lot of judgments coming out of the Supreme Court that will now put all the political parties and politicians to take just a step back and assess the situation. We've had a major development as far as electoral bonds are concerned, and today we've had this particular judgment as well, which is effectively taking immunity away from politicians and political leaders. As Joyita pointed out, that in the outside world this would be called corruption, it's black and white corruption, but inside the parliament it was being just thrown under this garb of I'm a lawmaker, so I need to work without fear, and therefore I need to be granted immunity.
Well, this is one more step towards accountability for our MLAs and MPs. It's a big step, but note that an ordinary individual, a citizen, cannot prosecute a parliamentarian or an MLA. This is something that they can do to each other, not so much from now. In this particular judgment, I expect means that if there is any bribe taking for asking questions, making speeches, or voting a certain way, irrespective of whether you actually do all those things, as long as you take the bribe, you can be prosecuted. The question is, by whom? Are you going to be prosecuted by other parliamentarians? Are you going to be prosecuted by ordinary citizens? I'm not sure ordinary citizens have the privilege of prosecuting parliamentarians or MLAs. So, there's a long way to go, but it is certainly a very favorable judgment coming from a 7-judge bench. The last judgment was that couldn't be prosecuted as a way of upholding parliamentary privilege. Here they made split the beam. Parliamentary privileges, there are many, but corruption, bribery cannot be included. That is a very important step that has been taken.
Okay, I'm going to get some clarity then from KV Dhananjay. KV Dhananjay, as Gautam Mukherjee also pointed out, does this judgment then grant, who exactly does this grant the power to in terms of prosecution anyway?
Well, the power of prosecution is available even to a private citizen. And in the case of P.V. Narasimha Rao, what in fact did happen is some of the members in fact went ahead and complained, and the matter was turned over to the CI. So it's also equally necessary to note that what today's judgment does is to deal with the offense of bribery, that is, offenses under the Prevention of Corruption Act. Now, there are certain things that are still absolute for members of parliament and state legislatures. Now, what are those whatever those absolute immunities? One of which is that they can't be sued for defamation for whatever they say. They could say the most outrage. This would be necessary, by the way, to preserve freedom of speech inside a functioning democracy. They are free to say anything that they want. And if they must be restrained, they will be restrained by the speaker or by the chairman, subject to the rules of the House. But for what they say in the parliament or in the state legislature, they can never be sued in any court of law on the ground of infliction of emotional distress or defamation or whatever. So they continue to have absolute immunity on that aspect. And they could in fact criticize a judgment of the court, they could criticize judges, and by doing so, they don't incur punishment under the contempt of courts. They can't be prosecuted for contempt of courts. So there are certain things that continue to be absolute. But what today's judgment does is to deal with the narrow case of bribery. Now, it's also important to note what bribery is under the Prevention of Corruption Act. I can actually give this real-life example of a member of parliament who in fact was accused of having received favors from a businessman to raise questions. Now, that constitutes bribery. That constitutes corruption under the Indian Prevention of Corruption Act of 1988. So it's important that, it's necessary for our parliamentarians and members of state legislatures to note that they wish to raise questions in the House, then that would be an official act. And for doing an official act, they cannot expect prizes or bribes or monetary favors from anybody. And should they receive it or demand, then they commit an act of corruption. So it's important to keep that in mind also. And because what we've seen is a member of parliament expelled, but not that the member of parliament was being prosecuted under the Prevention of Corruption Act. So going forward, a case like that may also lead to investigation and may also lead to prosecution under the Prevention of Corruption Act, because for a public servant to do any official act, should he demand anything other than his remuneration, that demand amounts to corruption. Should he receive anything other than his remuneration, that receipt amounts to corruption. Now, if it is a gift or a present, there are these internal rules within the parliament and state legislatures where there are rules for disclosure. So you will disclose and you will be free of, such prosecutions.
Okay.
Yes, but can an ordinary citizen prosecute? Can an ordinary citizen prosecute a bribe taker?
Yes, very much. Now, if the ordinary citizen has credible information with him, that a certain member of parliament or the state legislature is receiving money, probably from the opposition, to vote or to not vote in a certain way, maybe, say in a no confidence motion,
Right.
then that member of the parliament could always go and then complain to the anti-corruption police, and then the anti-corruption police is entitled to move forward, provided the complaint is is credible enough. It just can't be hearsay. Nobody can just walk into a police station and make allegations. There will have to be something backing. Credible information would be necessary to initiate a probe of that nature. But let me also point this out, which is, take Jayalalitha, who was a several-time chief minister of Tamil Nadu. She was prosecuted by a private person, Mr. Subramaniam Swamy, also under the Prevention of Corruption Act, but not for the offense of bribery, but for a different offense, which is to possess disproportionate wealth. Because the Prevention of Corruption Act recognizes that it's exceedingly difficult to catch a person at the time of taking a bribe. So what the PC Act does is to say that, look, what do you do if you keep collecting bribes? You're going to add that to your wealth, which means at a point of time when you're probed as to how there is an increase in your wealth, you would not be able to offer a satisfactory reason.
Yes.
So inability to offer a satisfactory reason makes that person culpable, for possessing disproportionate wealth. So she was prosecuted by a private person. So it's important to note that the Prevention of Corruption Act is not just about bribery. It's in fact one of the finest laws in the world that we have. It's important to enforce it.
Okay, Deshrata Nigam, at the same time, do you feel that then somewhere perhaps this judgment will be sending alarm bells? And do you feel that it could bring about the change that is necessary, or will this end up being another piece of paper that is ignored for the times to come?
Well, Devika, in fact, if you look at the evolution of Indian politics since 2014, there has been zero tolerance for corruption, and a number of scandals and corruptions have come up, and they are being investigated by the ED or the CBI. And this judgment, therefore, gives teeth to the government to pursue such kind of prosecution. And therefore, this judgment is going to go a long way, strengthens the hands of the agencies also who are doing their job, and to prevent the politicization of such kind of probe and investigation, which the number of political parties have started doing. Some of them have also withdrawn the consent given under the Delhi Police Act and Establishment Act and withdrawn the consent to the CBI. So that kind of thing should be avoided, and let the alarm bells ring to the people who are corrupt, who take the bribe. It is absolutely necessary for them to be alarmed and not to repeat anything of such a kind. And therefore, I think the two institutions in our democracy, which is the executive and the judiciary, seems to be aligned for zero tolerance of corruption. And the legislature, as we saw in the Mahua Moitra's case, has also taken a very stern view by expelling her from the parliament. Therefore, I think all the three institutions have to work well together, and the political parties have to see that the tainted people are not given tickets to contest elections.
And that's a conversation that we were just having earlier of how Sadhvi Pragya has been denied a ticket from Madhya Pradesh. So another big message there from the BJP as well on the sort of people that it probably wants to now bring into politics. But I'm going to leave the last question with both Joyita and Gautam. I just want to understand from you, Joyita, on the flip side, could this then become another tool for certain political parties to use against other political parties? Because I can foresee that that's precisely the arguments that will be made against this particular sort of a judgment, as Gautam pointed out, which gives power to politicians to raise these matters against their own colleagues in parliament.
Well, Devika, if you are looking at it as a tool, I mean, any law and every law can be used or misused by someone or the other.
Right.
So, just because that possibility is there does not mean that you will absolutely ensure that you do not cleanse the system, do not clean up the system, doesn't work like that. And here I have one, I mean, it is not exactly related to it, but one speaker spoke of, contempt of court. That is, I think this absolute power of the court also needs to be taken a look at, I mean, whenever a judgment, I mean, whatever the judges are saying, we are saying everything is fine. I'm not talking about this judgment. There are other judgments, I mean, we are always afraid of contempt of court. This is a contempt of court. In a democracy, it does not work like that. I wish the judges will look into this as well.
Okay, Gautam Mukherjee, leaving the last word with you on this issue itself.
Well, Devika, the other thought that occurs to me is what happens. I think bribery is a criminal, matter. Now, let us say an MLA or an MP is convicted. What happens? He's thrown out of parliament for 6 years. So this is very portentous in terms of its potential. Devika.
Okay. Deshrata Nigam, your perspective on this as well then, just to understand that is, just playing the devil's advocate here, that could this possibly then become a tool of misuse perhaps?
Well, Devika, in fact, as Joyita was saying, even the dowry laws, anti-dowry laws or domestic violence is being misused. That doesn't mean we don't need such a law.
Yes.
We do need such a law, but then we have a judiciary to look into it. If there is a misuse, you can approach the courts and get your grievances redressed. And that is the system of checks and balances we have in a constitution. In a democracy, that's the only way. We cannot have 100% foolproof system where the human aspect is taken out, and that human aspect means both use and misuse of a particular situation and the law. And therefore, if somebody uses it, its consequences should be very drastic and severe, and the law must, be very quick in punishing such people and redressing these grievances. And the delay in the system of judiciary is something that we all are bothered about, because justice delayed, as rightly said, is justice denied. If somebody is misusing the law, the courts must deliberate upon it and quickly pass the judgments so that people have trust and faith in the system.
Absolutely. Ironically, in 1998, it was the JMM which was accused of taking bribes. Shibu Soren's name had also come up, and that's when the law to give immunity was brought about, viewers. But today, it's been a full circle for the JMM, because it's in his own daughter-in-law's case, Sita Soren, where the court has set aside the interpretation and the 1998 verdict and their interpretation of what immunity to lawmakers and parliamentary privilege really means. On that note, I thank all of our guests and panelists for joining us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.